Okay, so if I look at section 5-33 in exempt signs, the following signs are exempt from the permitting process with certain conditions. Number 7 says vehicular
I
signs.
don't have a 33 in our city codes. I don't have a 33.
What is this?
It goes up to 24.
What is this? Vehicular signs are exempt.
I don't know what you're looking at.
Demanded to think this is probably okay because it is a sign which is affixed to a vehicle. Wouldn't be unreasonable for him to think that I'm probably okay, especially if his attorney told him that. I'm sorry.
No, that's okay.
I mean, what's your thought? I mean, when Mr. Suleiman...
My thought is he was cited for these two codes, and he's in violation of those two codes.
Okay,
So that's my thought. The
But the-
city's stand is that he's in violation.
okay. But the vehicular signs exemption doesn't apply here because...
Correct. He wasn't
Practice.
cited on it. That's not what he was cited for. He was cited for these two items, and that's what he's cited for tonight.
Okay. And your belief, what is your belief again, why the vehicular signs exemption would not apply?
Because it's a banner flag. It's like a banner that's been affixed to the truck.
All right. Do you have any argument that what we're looking at on that image is a vehicular sign?
Do I have any argument that it being
I mean, it is a vehicular sign, isn't it?
it's a sign on the back of something that's been built on a vehicle.
Okay. Okay.
What's the definition of a vehicular sign? I looked it up online. It's attached to or painted onto a motor vehicle. I mean, am I wrong by saying that?
No, I agree.
Okay. And your belief, what is your belief again, why the vehicular signs exemption would not apply?
Because it's a banner flag. It's like a banner that's been affixed to the truck.
All right.
I looked it up online. It's attached to or painted onto a motor vehicle. I mean, am I wrong by saying that?
No, I agree.
Ma'am, I don't think I have any further questions of you. Thank you.
Anything else?
No.
Do you have anything else that you wish to present, sir?
Well, I wanted to have some testimony come in from the owners and Mr. Zott, who's here now, who owns the vehicle in question. I want to get it before you have a special master, the arrangement which exists on this property, if that's acceptable. And the first thing I'd like to do is ask Abdul Suleiman some questions.
Okay.
Mr. Suleiman, you've been sworn in. Sir, you currently reside at 335 DeBary Avenue?
Correct.
And you acquired title to that property in September 2021 along with your wife, Jessica Orellana, is that correct?
Correct.
And you purchased that property from the former owner, Paul Zott, who's a dentist, is that correct?
Yes.
Okay. Could you explain the nature of the arrangement that you had with Mr. Zott in terms of the parking of the vehicle with the sign on the driveway of your lot?
Yeah, we have a contract, an agreement between us that, you know, he could park it on my driveway and he'll pay me $500.
Your driveway constituted a vehicular sign, did you not?
Yes.
And you also consulted with me on this, and is it fair to say, without breaching too much of the attorney-client privilege...
Sir, I want to caution you, or if you're going to waive attorney-client privilege, then it's going to open the door for...
Yeah, I don't want to do that.
Okay.
I guess my simple question is this. Is it fair to say that you interpreted the ordinance at question to have an exemption for vehicular signs, and that you looked at this sign attached to Mr. Zott's vehicle and thought that that exemption applied here?
Yes.
Okay. All right. Okay, well, that's all I have as far as testimony from witnesses, but I'd like to present some materials for the record
I have a couple follow-ups
Sure. Yes, sir.
for the gentleman. Sir, you indicated that you had entered into a contract with Dr. Zott to put this vehicle on your property for this $500 a month,
Agreement, yes, sir.
the agreement.
Yeah.
And when you entered into that agreement, did Mr. Zott advise you that he was already found in non-compliance with the city of DeBary?
After we bought the house, then all this fall through, didn't before. You know, like after we bought the house, then things came out slowly. You know?
Okay, you
Yeah.
found out after the fact that he was cited for it.
Yeah,
And-
find
and
out
was found in
after,
violation.
correct, after I bought the house, we kind of received letter, or he received letter. It wasn't our name, and, you know, we have to reject it, or, you know, the process.
So are you saying that the property was not in your name at the time he came into the hearing?
Oh, well, no, it is in my name.
No, was it in your name at the time he went to the
Yes,
hearing?
it was in my name when it came in his name, yes. The
Okay,
property was in my name.
and you were noticed, were you not?
Well,
No, we were not noticed.
no, we didn't.
So
Because I didn't open the letter. I didn't open it.
But
It's
the
now,
letter
it's
came
now
at
my
the
name.
name of-
It's in his name and I reject it. Basically, I say the wrong
Okay.
address and let it go back.
And so you were advised then after the fact that he had already been found in non-compliance for having that signage on the property, is that right?
After that, yes, we discuss it and he told me there's a city and etc. and we know about it after that. But we removed the sign. We did remove the sign after that. And after 3, 4, 5 months, we put it back because, you know, we thought it's gonna be fine.
Okay, so I'm just trying to wrap my head around, so after you were advised that the city had already found him in non-compliance, you removed the sign for a period of time, and then later you sought legal advice and you believe that it is okay, and so you've now put it back, is that right?
I put it back because it wasn't me, it was his non-compliant. It wasn't in my name, you know what I mean? So it
Right.
wasn't my name.
But when you
So-
put it out, you already knew that.
Yeah,
he-
of course, yeah, I would know that he is not compliant and it wasn't his name, but I put it, and the reason I did, because I want the income, $500. But, I mean, I thought it's gonna be fine. I didn't know it was gonna be, you know, I received a letter and we processing around.
So you thought that we would hold him in violation, but not you?
Well, that letter in my name, so I know if you guys find me in violation.
Okay.
Yes, sir.
All right, that clarifies my questions.
Yeah.
Okay, what else do you have, sir? I'm sorry.
Well, just a couple of questions for you, Mr. Al-Suleiman. That prior process involving code violation didn't involve you at all. That involved Mr. Zott, correct?
Yes, the process is.
And Mr. Zott was not represented by counsel at the prior hearing where he was found in violation, is that correct?
Yes.
Yes.
And after you became aware of the ruling, you did remove the vehicle, or the vehicle, you had the vehicle removed until you sought the advice of counsel.
Correct.
Okay. All right. Okay, so we're here today and you have the advice of counsel, and your simple point is you want your day before this body so you can present your positions, which might be different from Mr. Zott's, because at the time he presented his, he was no longer an owner of the property, correct?
Yes.
And I might mention just for the record that there's a pending appeal in circuit court of that prior ruling involving Mr. Zott, which I did file on behalf of Mr. Zott, and which cited the issue and the concern that the property owners were not before the jurisdiction of the Code Enforcement Board at the time of the last violation. And we haven't got a ruling yet from the circuit court on that prior appeal. But it's a pure due process, right to be heard type of appeal. And I think it was a slight miss perhaps, because there was discussion at the last hearing about the property no longer being owned by Mr. Zott, even though he was the only person who appeared for the prior hearing, not the owners. And my simple point is these owners deserve their day before this
Oh,
board.
absolutely.
And that's why we're here today. I'm trying to help them.
But my curiosity came in with the fact of the sign was removed. during the occupancy of the same owner and then put back at some point in time, and now we're back again.
Yeah, I guess you could say testing the waters. But, you know, I'm prepared to present some additional argument.
Sure,
if we
only
need to
thing you have for
consider
me
it.
to consider, sir.
And I hope we can, I mean, we are talking about plain language of statutes. And when we're talking about statutes and interpreting statutes, it's the same, if you will, logical reasoning which applies to the interpretation of ordinances. And if I may enter this into the record, it deals with a definition. I can say that under Black's Law Dictionary, the term vehicular means of and pertaining to vehicles. And what I have here is a definition from a really good resource called Law Insider of the term vehicle signs. And if I can enter this into the record and approach. Sir.
Well, that's exhibit one.
I have one for you. Don't want to? Okay.
Well, that's exhibit one.
Thank you. So this is, and it's using the plain language, plain English language. Vehicle signs mean advertising or graphics intended to advertise business affixed to a vehicle, but does not include license plates, license plate frames, or vehicle brand. So I think we have a vehicular sign. I think there's no question that we're looking at the plain language of this ordinance, and it's fair to conclude that one person could look at that vehicle and determine that sign in that vehicle is a vehicular sign. Somebody else might look at it and say, no, that's not the type of vehicular sign that I think applies to that definition, but it's sort of up in the air. And so we're looking at an ordinance, and in dealing with the language of an ordinance, it's critical to note, and I'll cite a couple of cases, that ordinances are to be construed broadly in favor of the property owner, absent clear intent to the contrary. And this is the case of Ocean's Edge Development Corporation versus Town of Juno Beach, 430 Southern 2nd, 472. And I have a copy for your consideration. So following up on that, these broad concepts, the intent of an ordinance is determined primarily from the language. So let's look at the language. Municipal ordinances are construed upon the same basis as statutes, and the property owners are entitled to rely on clear language of a municipal ordinance. So we're trying to honor property rights. We're trying to narrowly construe these ordinances, and if there is differing interpretations of what an ordinance should mean, the interpretation which allows the broadest and freest use of the property should be the one adopted until, as Ms. Monhollen pointed out, a more narrow definition is adopted so that the owner knows exactly where he stands in connection with the issue. And here I just cited language from the case of Nash versus Fort Lauderdale Board of Adjustment, 462 Southern 2nd, 88, 4th DCA in Florida. And I cited it for the record. I'm not sure you need to consider it as an exhibit. But the point is, and I think it's very fair to say, and I think Ms. Monhollen might have basically agreed with me, that yeah, this is a vehicular sign. And when you look at the exceptions and the exemptions to the ordinance, there's a very clear exemption for vehicular signs. Now, what's probably going to happen, and I think you're probably going to be involved in this process with the town council, there's going to be a first and second reading on narrowing the scope, providing qualifications for vehicular signs, so that the type of sign that's before the Code Enforcement Bureau today might be exempted out, if you will, of the exemption. Maybe a size limitation, maybe some other limitation. But I think anybody reading the plain language of the ordinances here is going to reach a conclusion that an exemption applies here. Because this sign is a vehicular sign, then these other violations do not apply. This vehicle is lawfully parked at the Suleiman's property, at the owner's property, and I think it's only fair to reach that conclusion, that it was the owner's rights and the owner's, I think, I don't know how you want to characterize it, but I think the owners needed to bring this before the attention of the board, that they had a differing position on this than Mr. Zott had presented. And they read this ordinance, they read the plain language, and I think they reached a reasonable conclusion that the exemption for vehicular signs applied here, and that they deserve an opportunity to have that plain language tested before this board. And I would urge you, sir, to look at that plain language, apply it, and then as necessary, if the city of DeBary needs to amend its code of ordinances to address the situation and create more qualifications that apply to the exemption for vehicular signs, then we'll cross that road when we get to it. But I don't believe there is a violation here, and I believe that the exemption is applied squarely to the situation which is before this board.
Thank you.
I'd like to state something for the record. I don't consider it a vehicular sign. I consider it in violation of number 9 and number 22 for the sign being attached to the vehicle.
What's the definition of a vehicular sign? I looked it up online. It's attached to or painted onto a motor vehicle. I mean, am I wrong by saying that?
No, I agree.
In violation of number 9 and number 22 for the sign being attached to the vehicle. Number 22 for it being off-site signage. So the city stand is that they're still in violation of those two things that I cited them for, and we're asking for the fine to be imposed if it's not removed by 9 a.m. tomorrow.
Does anybody else have anything that they wish to present? Okay. Then in case CE 4432-335 DeBary Avenue, I find that the property is in non-compliance. I find that the property owner shall have until 9/9/22 to remove the sign, or a fine of $250 a day will be imposed, along with a $250 administrative fee. And I'll clarify and give reasons specifically for and on my ruling. I recognize, sir, that you are the one, based upon your presentation, that you represent both parties, including Mr. Zott. You know the arguments that he made. You know the testimony he presented when he was here. He talked about working out an arrangement of paying someone $500 in order to have the signage on the property. The property owners today had indicated that they removed it from the property once they realized there was a violation, and instead of waiting to see where that went, they went ahead and brought it back out. And I think so what makes this a little different is I am not persuaded by the testimony that they reasonably believed that it was an exemption based upon the fact that they were notified in advance before they put the sign out that the city had already found it in violation. And I believe that these were the exemptions that were raised by Mr. Zott during his presentation. They seem to be well versed in what happened in the hearing. They testified as to whether he was represented by counsel. They testified they had the letters, they knew it in advance. And so for those reasons, I think that they're in non-compliance, and that's the basis of my ruling. If they had been a property owner that had come to this property and had done this without any previous notification and indicated at that time that they interpreted it a different way, it might have had a different impact with the court here tonight. But the fact that they knew previously and chose, after seeking legal advice from the person representing the first person, that's the difference in the case, and so that's why I'm making the ruling the way that I am.
If I may. The prior case is under appeal because my clients were not part of that prior proceeding. And I just want to leave that for the record. And they were looking to have a hearing de novo today, a fresh hearing on this, because as I previously indicated, Mr. Zott at the prior hearing at that time was not represented by counsel, and they wanted an opportunity today to present their concerns about the applicability of the ordinances in question. And that's what we've done today.
Sure.
And I understand your ruling to the extent that we're looking at a prior violation, which is under appeal. I respectfully disagree, but I do understand.
Right, and for clarity purposes, they had a de novo review, but when they brought up and when the testimony came out that they were aware, initially the presentation was, we read this and had no reasonable belief that it was a violation. And then having the specific knowledge that the city had already found it in violation, and coupled with the fact that they removed it after knowing it was a violation, and then choosing to come back into, as you put it, I'll quote you, to quote, test the waters. It's just that. It does not present where a person would come in at first blush and say, I had absolutely no idea anybody would say a word about this and it's not clear to me. They reacted by your client's testimony and removed the vehicle. So that's the basis of how that came about. So, all right, that concludes that case. Thank you very much, sir.